very much.
No problem, Fiona.
Thank you. I'll just introduce myself here. Hi. While we're waiting, we are expecting a huge number of people this morning. We have 60 people registered for the webinar, and we have 40 have attended. It's 11:04, so we might wait a minute or two. I'd like to thank, this is Fiona Lewis here, CEO of County Wexford Chamber. Good morning, everybody. I would like to introduce you to my colleague, Karen. Karen is going to be our host today on behalf of County Wexford Chamber. And Adrian Toomey, of course, our employment law expert and also a board member of County Wexford Chamber. We're delighted that Adrian has given his time today to share with us the most current information regarding the government's roadmap and to returning everybody to work. And thanks very much, Adrian, for facilitating this again.
More than welcome, Fiona.
Thank you. Just while we're waiting, it's worth checking out Adrian's original, our first webinar, which is on our website on countywexfordchamber.ie, and it was the 5 big questions that employers were asking. Some of it will still be current, maybe there's been changes to some of it, but certainly it was very informative at the time. And also, last week we were very fortunate to have an international expert, occupational health specialist, Dr. Shane Farrelly, who gave us phenomenally important information regarding preparing for the returning to work and those things that we should be considering. That is also available on our website. So I think without further ado, Karen, I'm going to ask you, would you mind awfully starting the webinar again, please, on behalf of the people who have just joined. And thanks very much. And that's the last you'll hear from me.
Hi, we'd just like to welcome everybody to County Wexford Chamber and Wexford Ireland SkillNet. And we pass over to Adrian Toomey now.
Good morning, everyone, and thank you for taking the time to join us this morning. I hope everybody's hearing me okay, and I apologize for the lack of video feed on my part. That might be a good thing from your perspectives, because even though my daughter has been doing a wonderful job on hair and makeup, the plastic surgeon hasn't been accessible over the last few weeks, so I'm not looking at my best. If we can move to the next slide there, Karen or Fiona, I'll just take you through very briefly what I'm going to discuss with you this morning. The first point that I want to address is the legal background in terms of where we stand right now regarding COVID-19 and the fact that so many workplaces are shut down or are operating on a restricted basis. So just a few points of law. I'm not going to get too technical, but just to give you a little bit of background in terms of principles that will be coming to bear in terms of the other issues that we need to discuss. Moving on from that, I want to explore briefly who exactly can work at the moment from a legal perspective. Some confusion has been arising on this at a number of points during the crisis. I found last week I had a number of companies contact me looking for advice as to whether or not they can return to work, and with about 50% of them I was in a position to say, look, you're already entitled to be working. You don't actually need to be closed at all. And the other half, unfortunately, I wasn't in a position to give them quite such positive news from an economic perspective. So I want to briefly explore who can work at the moment. Then I want to talk to you for a short while about the 5 phases of the government's roadmap and essentially ask or answer the question, who can return and when? Now, everything is provisional at the moment, of course, and the government has indicated that it will be taking medical advice through the summer and following that advice, and may need to revise its plans. It's a little bit less clear-cut than perhaps the situation in the UK based on Boris Johnson's announcements last night, although I have to say I, for one, would prefer to be operating here right at the moment. I think the priority is slightly different. There's a little more emphasis on the health and safety of citizens. That's just my interpretation. I hope I'm not causing any offence to anyone when I say that. So we'll have a look at the government's roadmap briefly. And then we had a very significant development over the weekend, which caused me to go back and rework all of the slides for today and the presentation, and apologies to Fiona and Karen and their colleagues at County Wexford Chamber. That resulted in my delivering the slides to them in the early hours of this morning rather than on Saturday as I had previously hoped. So sorry for that, ladies. But it is a significant development because the Minister, in conjunction with the social partners, as we used to call them, published a Return to Work Safely protocol on Saturday. It's a document of approximately 25 pages in length, and it indicates that a number of obligations are going to be imposed on both employers and workers in the context of returning to work over the next couple of months. Some of those obligations are relatively onerous. I think it's inevitable that many employers will fail to abide by them. I suspect there's going to be some legislative interventions taking place over the summer that will give teeth or force to that protocol, and that will at the same time create legal exposure for many companies up and down the country. I know that there's a number of my colleagues in the legal profession on the line today, and good morning to you all, and I hope you're keeping safe and well. I know that we're all worried in the legal profession, as in every other profession, about the security of our businesses going forward. But I suspect we're going to have a flood of work at the end of all of this, and that's bad news for everybody else who's on the line, unfortunately. But that Return to Work Safely protocol, I think, is going to be instrumental and critical in quite a bit of litigation down the line. And then finally, I want to touch on the current position in relation to redundancy, because as organisations are given liberty to return to work, I think we'll find that quite a number of them won't be in a position to bring everybody back. In fact, we'll be reducing their workforces. So I want to talk to you a little bit about that towards the end of this morning's webinar. I'm hoping we'll have time to draw a few conclusions and to take some questions, and I'm more than happy to deal with any questions that you might have in relation to the issues that we're discussing today. Fiona, Karen, if you could take me to the next slide, I would appreciate that. Thank you. So just looking at the legal background, and we don't need to get into too much complexity on this, but I would like, if we just looked at 4 points quickly and got an understanding of the key basic legal provisions that are relevant right at the moment. So the first point that I wanted to make here is that the government introduced regulations at the outset of the lockdown under the Health Act 1947. The long, wordy name of those regulations is on your screen there. So it's the Health Act 1947, Section 31A, Temporary Restrictions COVID-19 Regulations 2020. Now, what those regulations did was they effectively made it unlawful for people to leave their homes, except for certain limited circumstances. And we're all relatively familiar with some of those exceptions. So we're well aware that we were permitted to leave our homes once a day for the purposes of taking exercise, as long as we remained within 2 kilometres of our homes. It's now been extended to 5 kilometres by reason of an amendment to the regulations. And there were a number of other exceptions mapped out as well. Now, critically, one of those exceptions was that you could leave your home to go to work if you worked in an essential retail outlet, or if you were providing essential services. And I remember the night on which Leo Varadkar made the announcements, panicking myself, because I thought, well, they're never going to class solicitors as essential services, and the lockdown is coming into effect within a matter of hours, and I left my home and charged into the office late on a Friday night to try to get a couple of things sorted out for clients, thinking that I wouldn't be able to leave home afterwards. But the definition of essential services is actually quite broad and complicated, in the regulations. And so many of my colleagues, I'm sure, like myself, we've spent quite some time trying to interpret those regulations for clients over the last number of weeks. We'll come back to that point in a little while, but the critical takeaway just at the moment is that the regulations make it a crime for citizens, for individuals, for employees to leave their homes. It doesn't make it a crime for employers to open their businesses. So that's interesting. For most of you, you can open your business and operate right now lawfully. It's just that you won't have any employees to do the work for you because they're not allowed to leave their homes. And you as an individual, you're not allowed to leave your home to run that business either. But the business, a company, for example, is not prohibited from operating right now. The crime that's created by the regulations is one that can only be committed by individuals. It's an interesting point of drafting. What they did effectively is they said that it's unlawful for you for residents to leave their places of residence in Ireland. Interestingly, if you don't have a place of residence in Ireland, then there's no restriction imposed on you at all. So that's why we've seen a situation where individuals who live in the north are able to drive around and do what they want with impunity in the Republic of Ireland because they don't have a residence in the 26th state. The third point on that slide there relates to a couple of very old legal ideas. The first one is this notion of frustration of contract. So, as we all know, the employment relationship is based on a contract, whether that's written or not, between the employer and the employee. And it's that contract that gives rise to rights, obligations, duties, etc., in relation to both parties. There's an old idea in law, the idea that if it is impossible for the parties to perform the contract for reasons beyond their control, then the contract is frustrated. In other words, it comes to an end. The law terminates that contract and terminates the obligations arising under it. And in theory, that idea of frustration could come into play in a situation like this. I can't attend at my office if I'm in a range of different areas of operation and my employees can't attend at the office. Are we therefore in a situation where the contracts of employment are frustrated and come to an end? Well, that could have alarming consequences. So I think when this is all over and the courts have to untangle the mess, what they'll probably say is, no, the contracts weren't frustrated and employees weren't breaching their contracts by not leaving home and coming to work. Rather, the contracts were temporarily suspended by reason of the regulations. Regulations don't say that, but I think that's what the courts will probably say. It's a temporary suspension of the employment contract in many businesses right now. The other point that I'm referencing on this slide is that we will have more regulations. It's inevitable, it's necessary, it's essential, and there's already been some indication that they are going to be on the way. I suspect we'll have more regulations by this weekend. We certainly will have more regulations by next week, and there will be further regulations introduced, I think on a 3-weekly basis, probably throughout the summer, as the restrictions are hopefully lifted, as hopefully the numbers of people becoming infected and sadly dying due to COVID-19 reduce. You might take me to the next slide there, Karen, if you wouldn't mind, please. These are a number of other legal points that I just want to briefly address in order to give us context and background and an understanding of some of the issues that arise when we come to tackle the thorny question as to who can return and when. The first point on the slide there is just a mention of the Safety, Health and Welfare at Work Act 2005. Now, many employers, most employers, hopefully, will be relatively familiar with the idea that's addressed in that legislation. So the legislation effectively imposes obligations on both employers and workers in terms of ensuring that we all attend at workplaces that are safe and healthy. The obligations on employers generally involve providing a safe place of work, a safe system of work, safe tools or equipment, and competent co-workers. And those ideas have been enshrined in law way, way back, well before the 2005 Act was introduced, in fact, by reason of a number of judicial decisions commencing in or around the 1930s. So we're familiar with those ideas, but those old ideas, the idea of providing a safe place of work, safe system of work, and so on, they have entirely new meanings and applications now in 2020 in the context of the global pandemic. And I wonder how many of us can guarantee that we can provide a safe place of work right now, that we can provide safe systems of work right now, and that we'll be able to do so over the next couple of months. So we need to be mindful of that idea, and we'll return to that point in just a little while. There is room for potential prosecution of employers under that legislation, and the Health and Safety Authority police it and will have a role in that context over the next few months. And the other point to bear in mind in relation to the Safety, Health and Welfare at Work Act is that there is scope here, or the danger here, of a rash of claims for negligence by employees against employers. So I had a number of conversations with employers last week where they were looking at reopening, and we felt that it would be lawful for them to reopen. They weren't prohibited from doing so by reason of the regulations, that it would be lawful for their employees to return to work, and that if it wasn't now, it certainly would be in a couple of weeks' time. But I had to point out to them that when they reopen, they do run the risk that if an employee contracts COVID-19 and becomes very ill, or, God forbid, dies, or brings it home and passes it on to, infects one of their family members, and that family member becomes very ill, or again, God forbid, dies, that there is scope for, or the danger of, negligence claims. Now, the response of insurers to COVID-19 has been interesting, and you'll find that some of your insurers are saying that the policies that you have in place at present are not covering claims arising out of COVID-19. So before any of you even think of reopening, do check what your insurance is like, because you might find that you're effectively self-insured or not insured in relation to those claims. And again, I don't want to give solicitors a bad name. I suspect we already have one, and I hope that none of my colleagues on the line take offense to this, but there will be solicitors out there sharpening their knives, waiting to bring claims against employers arising out of this COVID-19 crisis. So we need to be very, very careful to ensure that, number one, we do everything possible to protect the workforce when they return, and number two, that everybody follows the procedures that are put in place, and we minimize the risk of anyone contracting COVID-19 when they do come back to work. A point in relation to lawful and reasonable instructions that has been raised with me by a few employers. Some of them are saying, well, surely if we open or reopen, and it's lawful for us to do so, and we tell people that they are to return to work, we instruct them that they are to return to work, they must do so. And the answer is not necessarily a straightforward yes. It is under normal circumstances, because the employment contract obliges employees to obey the lawful and reasonable instructions of their employer. That's a concept that employment lawyers are very familiar with, and where employees refuse to obey those lawful and reasonable instructions, on many occasions over the years, I've been involved in cases where the employers took disciplinary action or dismissed the workers in question. But there is a caveat to that obligation to obey your employer's lawful and reasonable instructions. And that is contained within the word reasonable. The instruction must be reasonable. And just to illustrate the point, I want to mention briefly one of my favorite old cases, and we're reaching back a long way into history here. Robson and Sykes was an English case that arose in 1938. where a sailor was instructed to board a vessel and sail it from America to Spain, and transport goods, or help transport goods to a Spanish port. And the sailor refused because the Spanish Civil War was raging at the time, and he was worried that he would end up being seriously injured or killed as a result of sailing into the port. Now, in that situation, the employer said that he was refusing to obey a lawful and reasonable instruction. The court found that it wasn't a reasonable instruction, that if he was a soldier or a member of the Navy, then it might have been reasonable to instruct him to sail to a port where there was a civil war raging. But for a merchant seaman, as he was, it wasn't a reasonable instruction. And I wonder, will we find employees, when businesses reopen, saying, no, it's not a reasonable instruction to require me to return to work right now, because I'm at significant risk of contracting COVID-19, and that could be fatal for me or a member of my family. So I'm refusing that instruction, and I don't regard it as one that binds me. I tend to suggest that we will find that. I know many clients have already encountered that, and I'm giving them different advice now to what I would have given them a year ago, because of the circumstances in which we find ourselves. You're going to need to be as accommodating as possible in those circumstances, and I wouldn't urge any employer to push the boat out too far right now, because I think if they do, they'll get sued and they will lose down the line when the Workplace Relations Commission and the courts are fully functioning again. So, if I could go to the next slide, Fiona and Karen, please. That leads to the first big question, and that's who can work right now? Well, the answer is dictated by the COVID-19 regulations that I mentioned earlier. I've shortened the very lengthy title on this slide, hope you don't mind. There are two schedules in that set of regulations. Schedules or schedules, I never know which word to use, but hopefully you're following me in any event. The first schedule lists the essential retail outlets that are permitted to open at present, and the second schedule lists the essential services that are allowed to open and operate right now. I'm misleading you there when I say open and operate. I should really say the essential services that employees are allowed to travel to perform, because again, like I said earlier, it's the employees, the workers, the individuals, the citizens who are restricted in terms of their movement. So just to look at each of those for a moment, we'll look firstly, if you don't mind moving to the next slide, please. We'll look firstly at...
We have a question. Is it okay to take a question?
Yeah, I see the question coming in there. If someone refuses to return to work, will they still be entitled to claim for the COVID-19 payment? Well, that will depend on the circumstances. If they are sick, if they have COVID-19, for example, then they're ill, and they will be entitled to apply for payment from social welfare without any difficulty. If they're not ill, but their GP advises that it is unsafe for them to return, and they need to continue to self-isolate, then they will be entitled to continuing payment from social welfare. If there's no illness existing and the GP or doctor is not advising that there's a problem, then I think they won't be entitled to the payment. They'll probably still get it, but the answer to the question in terms of what I think ultimately you're interested in is from the employer's perspective, you can simply say, we're open for business, your job is there, we'd like you to come in, we've taken the necessary steps to protect you, you're not going to be paid while you're refusing to attend that work. That having been said, we're not going to take disciplinary action against you in the current circumstances. Apply for whatever social welfare payment you can get. I don't think they'll be entitled to one, to be perfectly honest. I think they might get one just for the moment, while social welfare is struggling to cope with the vast numbers of people whom they're dealing. think later, if it's looked at, social welfare will take the view, well, actually that individual wasn't entitled to payment and they'll need to refund us. And if anyone contacts you, you can say to them, social welfare, revenue, whoever, we are open and our workers are back at work if they've been willing to attend, but we are certainly not refusing to permit them to return. I hope that answers your question. There's lots of ifs, buts, and maybes because there are lots of individual circumstances arising. But the short answer is, I don't think they will have that entitlement to payment. But I suspect they will get payment for a number of weeks yet until realization dawns on social welfare. So just coming back to the point about who can work right now. There's two schedules to the regulations, like I say. The first one deals with essential retail outlets, and I've listed them out there in bullet point form. I'm not going to go through all of them because we'll run out of time here very quickly. You can see those who are providing food and beverages on a takeaway basis are allowed to be open right now. Those who are selling newspapers, interestingly, even though they don't have to be specialist news agents, are allowed to open. And that means, of course, that they're going to be able to sell everything else that they normally sell as well. And it works on down through the list there. Now, this bullet point list that I've included on the slide is just the headings in the regulations. There are further definitions in the regulations themselves. And if you see yourself on that list and think, well, wonderful, I can reopen, then I would urge you to take legal advice in relation to the detail of the regulations themselves. So by way of example, and I'm just pulling up the regulations here in front of myself, I've made mention in the slides of, for example, fuel service stations, heating fuel providers. In the regulations, that's the only language that's used in relation to them. However, the next bullet point, about just over halfway down the slide, I've mentioned items essential to the health and welfare of animals. What the regulations actually say is that you can travel to work if you're working in an outlet selling essential items for the health and welfare of animals, including animal feed and veterinary medicinal products, pet food, animal bedding and animal supplies, whether on a retail or wholesale basis. So if you sell pet food out of your shop, you can open. Might only be one item you're selling, but you can open based on those regulations. So it is worth taking advice from your solicitor on whichever one of those bullet points you might fall under, because there's a bit more scope for some and perhaps a little less than is implied by the headlines there for others. I've spoken to many employers over the last few weeks who said, well, I can or I cannot open, and they're saying that based on their interpretation of the list that's been published by the government on the internet of who can operate. But the list published on the internet is just those headings or something like those headings. It doesn't go into the actual detail that's contained in the regulations, and it can be misleading. So be careful about that, because if you open and you're not in fact entitled to open, you're asking each and every one of your employees to commit a crime every time they come to work. And it's a crime punishable not just by a fine of up to €2,500, but also imprisonment. Now, we're not seeing too many people imprisoned for breaching the regulations, and I suspect we won't see too many, but I'd be very reluctant to ask one of my employees to risk getting a criminal record in current circumstances. If we can move to the next slide then. I'm not sure if Fiona or Karen, who's operating the slides right at the moment. Is it you, Karen?
Fiona is looking after that.
Fiona is,
sorry,
okay,
Adrian, we have another question there for you.
Super. I can't see that question now.
Okay, if an employee refused to come back to work, even though we facilitate, do we report to welfare that we've offered them their position back?
I don't think you're under an obligation to go and tell welfare. Look, the safest answer is probably yes, inform welfare that you're reopened and that your employees have been invited to return to work. I'm not sure I'd be maybe I shouldn't say this, I'm not sure I'd be charging off to start reporting people left, right and centre at present and creating difficulties with my own employees. But yeah, the safest answer is to say communicate to welfare your reopening on a particular date, information around the reopening, and who's going to absolutely. So who can work right now? I was looking at retail. The next provision in the regulations is that these types of retailers, the ones listed on the screen now, can open to provide emergency services only. Okay, so opticians don't open and operate as normal. They're only providing emergency services. But again, with each of these, there's further definition contained in the regulations. Fiona, if we could go to the next slide, please. The second schedule in the, thank you, second schedule in the regulations deals with the provision of essential services. And we've all been trawling through this, or many of us have been trawling through this schedule over the last few weeks, trying to work out whether or not we can open our businesses. There's a list again here, similar to the list that you'll find on the government website. And there's further detail provided in the regulations. So by way of example, you'll see that I have, sorry, I'm just moving to on a second screen here to look at the actual regulations themselves. So manufacturing, I've said certain manufacturing operations in the bullet point. They're actually a string of types of manufacturing listed in the regulations that are okay in terms of operation right now. So bizarrely, the manufacture of wood pulp, paper and paper board is listed as one of the types of manufacturing operations that can open. So it's worth drilling down into the detail contained in the regulation. I love the fact that there's so much emphasis put on bicycles. It looks as if the Greens are already in government, because the last bullet point there is you can open if you're renting and leasing vehicles and bicycles. There's another provision in there about repairing bicycles and so on and so forth. The next slide again, Fiona, if you don't mind. Should just finish the list there. Public administration, human health and social work activities, publicly commissioned community and voluntary services. All of these are areas in which it is at the moment permissible to attend at work. But I don't want to labour the point in relation to the regulations and what's permissible right now too much, because many of you have already looked at that in detail. So Fiona, if we could go to the next slide. I want to talk to you about the roadmap.
Adrian, we have another couple of questions there for you.
I wonder why I'm not seeing them. Anyway, go on. Sorry, Karen.
Yeah, if an employee refuses to come back, can you terminate their contract?
I wouldn't rush to terminate anyone's contract right now. I think the first thing that you need to ask is, well, why? Why are they refusing to come back? If they say to you, well, actually, I live with my two very elderly parents, both of whom have significant medical conditions, and I'm terrified that if I go to work and contract COVID-19, even though I may be asymptomatic or it might do no harm to my health, that I will come home and effectively kill my parents. In those circumstances, I think at a later date, the Workplace Relations Commission would look at you if you dismissed them or that individual and say that was extraordinarily harsh and unfair in the circumstances. So the answer to the question, I think, is generally going to be no. I'd look at the individual circumstances, but I would say generally no. If on the other hand, they're saying, I don't want to come back to work because I prefer sitting at home twiddling my thumbs, getting the COVID-19 unemployment pandemic payment, well then I think you're being invited to almost engage in a conspiracy to defraud social welfare. That would be a different situation. There, I might be willing to take disciplinary action, but I'd still be hesitant about dismissing anyone arising out of this current COVID-19 crisis, unless the one dismissal that I probably would be supportive of is where you do return to work and somebody is threatening or bullying colleagues by coughing in their direction, spluttering in their direction, spitting in their direction, that type of thing. That type of activity, I think, may well lead to dismissals that will be upheld as lawful. Dismissals for refusing to return to work right now, I think, are too dangerous. You need to wait until we're well into the government's roadmap being implemented before you could look at that. And that leads me to ask that we move to the next slide. Karen, if there was another question just there, I'm more than happy to take it.
There's one more. Dentists have not specifically listed on the government's roadmap. Unsure if we, under legislation, can provide emergency treatment only.
Good question. Let me just pull up the regulations here. Well, they may not be specifically listed, but there is provision in the regulations for those who are engaged in human health and social work activities. So I'm not going to take too long to explore that one, but it's lawful at present for you to leave your home, to engage in work where you're providing services that relate to human health. And they've listed a number of examples. So providing emergency dental services is one of the ones that's listed there. So you can't open and engage in your regular dental practice as normal. People who are looking for, I don't want to get into technicalities of dental practice, because I have to be honest and admit that I don't visit my own dentist as often as I should. But if I'm coming in to get my teeth whitened, that's not an emergency situation. If, on the other hand, I'm in screaming pain and I have an infection potentially, well, I think you can quite reasonably say that you're engaging in the provision of emergency dental services there. So yes, you can engage in that activity. Do be incredibly careful about your employees. If you have a dental assistant or a dental nurse, for example, working with you, you don't want to unnecessarily expose them. But I tend to find in general dentists, more than almost any other profession, are top class when it comes to hygiene, avoiding infection, etc. And you're eminently qualified to analyze what needs to be done in those circumstances. Now, there's another question after coming in. Hello, if there's not enough work to keep all employees, can we terminate contracts? Well, then you are looking at a redundancy situation. Yes, and I'll come on to redundancy very shortly. But be careful to ensure that this is a permanent situation, because if you're reopening and you have a limited workflow at present, then probably the first response is simply to bring back a small number of employees and leave the others either laid off and on, for example, the COVID-19 pandemic unemployment payment, or arrange for short-term working. Now that does logically lead me into the next slide, Fiona, so if you could move us along there to the next one, please, that would be great, because it relates to the government's roadmap. So looking at the roadmap, it sets out 5 phases. Now, the national group, the National Health Group, that's been advising the government, has talked about 5 phases across a number of different sectors. I've zoned in just on economic activity or work here and tried to set it out in one slide. And there's not a lot more detail in the roadmap than is provided on this slide. In fact, in relation to work, there's no more detail in the roadmap than is in front of you here on the one screen. Okay, so the first phase commences on the 18th of May, and we're rapidly approaching that. It's just a week away. And in that first phase, they're indicating that they'll allow for the phased return of outdoor workers, and they give the examples of construction workers, gardeners, and allotment workers. Beyond that, they say that anyone who can work remotely, should do so. Okay, that's all the guidance they've given us just yet. Now, the 18th of May is next Monday, and we're looking at a situation where lots of people are looking at potentially going back to work next Monday. I don't think, in fact, the degree of relaxation is going to be anything like what the general public is anticipating and what many employers are anticipating right now. So I expect that we'll probably see regulations introduced Friday night at the earliest, possibly Saturday or Sunday. They probably won't be published online until Monday or Tuesday. We won't get clarity as to exactly who can and cannot return until then. And in fairness to the government, they probably don't know who can and cannot return right now because they're waiting for further advice from their medical and scientific advisors. So if I come across as being critical of the government or the state at any point here, I don't really mean to be, because they're dealing with an extraordinary situation and they have a lack of forewarning and information that is unparalleled, really. But what they're looking at next week, hopefully, potentially, is those who work outside. Now, working outside while remaining engaged in social distancing and so on. Second phase commences the 8th of June. I'm just mindful of the time, and I know that I've gone on far too long already, and I'm just getting into the meat of what I wanted to talk about today, so apologies for that. Second phase commencing the 8th of June. Solitary workers, they're thinking, might be able to return. People who can maintain constant social distancing. And I'm looking at that myself in terms of my own office. Can I put people in separate rooms so that they have constant social distancing? What disinfecting will I need to undertake in the office in order to ensure that people can move in and out of the office without running any risks? Do we need to wear masks? Do I need to be taking temperatures when they attend at work? Some of that might sound extreme to some of you, but unfortunately I have some bad news for you on that front, because that's what we're going to be expected to do based on the protocol that was published on Saturday. Interestingly, they're saying on the 8th of June, or in that 3-week period, everybody should be developing plans for returning to work. Just plans, and those plans should include social distancing, hygiene and cleaning, compliance in high-risk situations. I don't know who's been following the news in other countries, but my wife and I are fascinated by what's happening in the US and watching Donald Trump's daily briefings while he was doing them. And I note that in the US, there's a lot of emphasis being placed on tattoo parlors and barbers and hairdressers returning in certain states. I have to say, I would see those as being high-risk situations and very unlikely to be allowed to return until phase 5. That's just my guess at present. They say that your plans should include provision for pregnant and medically vulnerable workers. Now that's interesting, and I've put 2 stars after it. They're effectively indicating that not all workers can return at the same time, that certain categories of workers are more at risk and they won't be allowed to return at the same time as others. Down the bottom of the slide, you'll see my 2 stars again, where I say that employment equality concerns will potentially arise, because now we're looking at the government possibly advising us that we should be discriminating against people with disabilities over the course of the summer as we return to work. I think there's going to be a flood of litigation there as well. That may be, sadly, where I make back the money I'm losing at present because of the lack of operation of the Workplace Relations Commission right now. And they talk about extended opening hours to ensure that we can comply with the 2-meter social distancing rules. So by that, they're saying, look, you might work from 9 to 5 at present, but look at working 24 hours a day and having, let's say, 3 shifts. So only a third of your workforce is in work at any given time. Now, I know there's going to be employees who will kick up and scream about being asked to come in and work at night or work in the evening when they normally work during the daytime. So there's all sorts of issues going to arise there. Third phase commences on the 29th of June. And they say that organizations can return where employees have low levels of interaction with people. That's going to have to be defined in regulations in June. And it's going to give rise to all sorts of argument again. And still they're saying social distancing needs to be maintained. Now, interestingly, in the UK, the Prime Minister, Boris Johnson, appears to have announced last night that they expect everybody who can't work remotely to go back to work on Wednesday. So they're going back much, much faster than we are. It'll be interesting to see how that develops. And I think what happens in the UK and what happens in America and in other countries will inform our government as to how they might respond. Because if we see further spikes in COVID-19 infections and deaths in the UK, then our phased and slower return is going to become possibly even slower. If, on the other hand, they return in the UK, and seen large numbers of people in images on media this morning, large numbers of people on the tube in London, for example, very busy, no social distancing whatsoever. If they see spikes in London in the next 2 weeks, well, number one, it'll lead to a very sad situation in the UK, but number two, it will have an impact on the thinking here. If they all return and nothing happens, there's no upward spike, then maybe the government will speed up the timetable. Phase 4 at the moment is anticipated as commencing on the 20th of July. And they're saying at that point, organisations can return where employees cannot work remotely. So that's effectively saying that on the 20th of July, we'll start doing what the UK are doing this week. If you can't work remotely, you can go back to work. If you can work remotely, you stay at home through to the end of July and into August. And they say we'll limit the number of workers interacting by using shift work, staggered hours, etc., over a 24-hour day. That will be challenging. The 5th phase, commencing the 10th of August, they're saying a phased return to on-site working for others. So basically, everybody's coming back in August, is what they're indicating. But higher risk organisations will need to implement plans for progressing towards a full return of all workers. Now, that's a full return of workers. That doesn't mean a full return to normal activity necessarily. So if you own and operate a nightclub, for example, I don't really see the government, while they're saying your workers can come back, I don't really see them approving the operation of nightclubs in August, or pubs, or large-scale football matches, etc. The big development over the weekend, and I'm afraid I'm going to run out of time before I even get to touch this in any detail, is that the Minister, Heather Humphreys, launched a return to work safety protocol. Apologies for the typo on the top of the slide there. It's return to work safety protocol. Was launched on Saturday, and that was developed by government in conjunction with the Health and Safety Authority, Health Services Executive, after consultation with the Employer Labour Economic Forum. I'm sorry, Fiona, I may have jumped ahead of slides there without even asking you to move the slides along.
Not to worry, Adrian, you're just keeping me on my toes.
Thank you, I appreciate that.
Could I
go on, Fiona.
Could I just suggest while I was talking to you there, that there are questions, there's a box you don't seem to see, which is questions and answers. We have 4 questions at the moment. Would you like to take them now, or would you like to wait?
You. Sorry, I was looking at the chat box. Here we go, questions and answers. Thank you very much for the explanation there. Okay, so the first question for Emer, should we approach our insurance to now include public liability cover, to include exposure to COVID, etc.? Practically, how difficult would it be for a customer to prove they contracted the virus in your retail premises? Again, presumably such an addition to cover will increase our premium, but how easy would it be for insurance not to pay out should a claim arise? Such a difficult case to prove. Well, Emer, you've got about 6 questions in there, in fairness to you. I think if you have insurance in place already, that's where I'd start. Look at what your current cover provides. Secondly, if you want to go out and get additional cover, I think it'll be extremely difficult to do that now. And it could be very expensive to do it now, but do look at it. And see what quotes you can get if you don't already have insurance in place that covers you. Would it be difficult for a customer to prove they contracted the virus in your retail premises? Yeah, it could be, but there's going to be very detailed contact tracing going on, and I'm just about to touch on that in terms of the return to work safety protocol. One of the steps that employers are going to be required to take, and this is going to be difficult, is maintaining a contact register in order that contact tracing on a national level can operate easily. So I think it may not be as difficult as we suspect to trace where COVID-19 came from. it will certainly be much easier to prove how you got COVID-19 than it would have been to prove how you got the flu last year. So I think the proof is going to be tricky, but not as difficult as we might imagine. And you should definitely look at having insurance. The starting point is covering your workers, but then the general public, absolutely, it's worth seeing what cover you have in place and how easy it would be to get cover and how much that would cost. Second question there that I had missed was Heritage Park. We're an outdoor heritage park, private NFP. When would you think from the phased list we could reopen? Well, it's difficult to answer that without having further detail from the government. I think your outdoor workers can expect that they may be returning to work from next Monday. People who work indoors will be later. I think at the moment, we're probably looking 20th of July, 10th of August, so phases 4 or 5. But actually having members of the public coming in is a different question. I suspect you won't have members of the public coming in based on the government's roadmap until the end of July at the very earliest, and I suspect August is probably more likely. Can't wait to go there when that does happen, because it's a fabulous place and I love to visit there every year with the kids. So best of luck with your reopening. I'm sure you'll have a flood of people in the door as soon as you can get that. Eugene has asked a question: spouse of pregnant woman returning or failing to return. Okay, so I'm assuming what you're saying is that an employee might, for example, have a wife or partner who's pregnant and is worried about contracting COVID-19 and transmitting it to that spouse or partner at home. If I was in that situation, I would definitely have a huge concern, and I think we have to be conscious of that type of situation and sensitive in terms of dealing with it. The government's roadmap does specifically mention pregnant workers, so they're indicating that there's a particular concern for pregnant women in relation to COVID-19. And I think in those circumstances, you're looking at one of two situations. Either the partner remains away from the pregnant woman, which is going to be extremely difficult, quite harsh. I think will only be justifiable if they're providing absolutely essential services. But I think I'd probably be looking at facilitating special leave for that individual pending medical advice. And I'd be looking to, if you do have an occupational health physician from whom you can take advice, and for those smaller organisations around County Wexford who don't have an occupational health physician, I'd be happy to recommend a number of them. Some here, some in County Wexford, some outside of County Wexford, who can give you guidance on that. But I think be as facilitative as you possibly can in those circumstances. The last thing anyone would want is a situation where, God forbid, something happened to that baby. None of the individuals involved would ever be able to live with themselves afterwards. And Margaret is asking, construction phase 1, is this outdoor only? Most of our work is on building sites, but indoor and closer to completion. Well, they are saying outdoor only at the moment. We'll get further guidance at the weekend. But right now, I wouldn't expect to see the government authorising indoor construction work. I think those people might be returning to work, some of them in phase 2, where they can argue that they're solitary workers, they're in a room on their own. Imagine a plasterer, for example, might possibly be able to work on his or her own in a room. One might equally argue that they shouldn't be going back until phase 3, where they have low levels of interaction with people. So I think the answer to that question, Margaret, is outdoor only at the moment, or on Monday, with the rest returning later on. So you might be impacted by that. You need to watch very closely what's announced at the weekend. And obviously, we'd be happy to further advice. Neil, how about return to work with an employee with an underlying health issue? Very similar to the pregnant worker. Very similar to the pregnant worker. We're going to have to be extremely careful there. you've competing legal obligations, Neil. One, under the employment equality legislation, not to discriminate against people with disabilities, but two, more importantly at present, I think, under the Safety, Health and Welfare at Work Act, to ensure the safety and welfare of your employees at work. So, yeah, you're not going to be bringing people with significant underlying health conditions that are adversely impacted by COVID-19 back anytime soon, I suspect. So the return to work safety protocol I was talking about, apologies that I'm running a little late. We are getting closer to the end. I do appreciate that some people might need to leave us, but hopefully we'll be through the rest of the presentation in the next 5-6 minutes. If I could ask you to, sorry, you are on the slide I wanted there, Fiona, apologies. I'm looking at 2 copies of the presentation on 2 screens. So the social partners, or what we used to call the social partners, were consulted by government, and they've been party to this new safety protocol. And it sets out steps that must be taken by employers and employees before workplaces reopen. Now, I think the choice of the word must is interesting, because the protocol itself is not legally enforced or enforceable right now. This is just guidance that they've published. But I suspect the use of the word must and some of the other language in the document and some of the comments that have been made around the document indicates to me that this protocol will be given legal backing by way of regulation at some point over the next few weeks. So I think it's well worth having a look at that. Now, I've got a link in the slide to the publication itself. You probably can't operate that link right now from the screen in Zoom, but we will, I'll ask Fiona and Karen to arrange to have the slides circulated to you by email afterwards. You'll be able to use the link then to access the Return to Work Safety Protocol. You can Google it anyway, and it's relatively easy to find on the internet. It's very well worthwhile having a look at to see the detail of what's being required of you. Okay. Karen, that's a very cute colleague has joined you there.
Yes, he just dropped in some post. I do apologise.
No, you're fine. You're fine. These Zoom calls and meetings and webinars have been fascinating over the last few weeks in terms of what's been going on in people's homes. Anyhow, so there's certain steps that must be taken. And they're saying that a stakeholder forum is to be established, and what they're really saying there is that it's going to be continuing dialogue at national level between government, the trade unions, and employers' bodies. So the unions are having an input. If we go to the next slide, Fiona, please. Just continuing on in relation to the protocol, it's saying that employers who are returning to work must, in consultation with nominated worker representatives. Now here the unions being clever, right? Because they're forcing their way into a consultation with employers around the country arising out of the COVID-19 epidemic. And in certain cases that's right and appropriate. In other places that might cause some problems. So they're saying that you must, as an employer, develop and or update a business COVID-19 response plan. When I saw that, I thought, great, that's going to give rise to a whole host of problems and requests for legal assistance. Most of you on the call won't be too happy to see that you're getting a string of obligations imposed on you, but as employers, you're now part of the national response to COVID-19. Second bullet point, develop or amend policies and procedures for prompt identification and isolation of workers who may have symptoms of COVID-19, including keeping a log of contacts. I nearly collapsed when I saw that, because it's going to be difficult enough to reconcile GDPR and data protection rules with keeping a log of who your people contact while they're at work or are in contact with. So now we have to track and trace in work who speaks to whom. That might give rise to interesting developments out at the smoking shed in the workplace or in the canteen. In any event, that's a step that we must take according to protocol. We have to develop and consult, communicate and implement workplace changes or policies, and we have to implement COVID-19 prevention and control measures to minimize the risk to workers. So that's all employers. All employers are being expected under this protocol to implement prevention and control measures, including temperature testing. Now, I'm kind of wondering, am I expected to stand at the door of my workplace and check the temperature of everybody who's coming in? I can imagine that working in a big manufacturing plant. I'm trying to work out how it'll happen in my office or in lots of SMEs up and down the country. If we haven't been cleaning the thermometer adequately enough or disinfecting the thermometer, I worry about how everybody's going to comply with this and about the practical problems it might create. Further details are set out in the protocol. Do expect to see regulations or legislation around this, and absolutely expect to find the protocol being recited or referred to at hearings before the Workplace Relations Commission when the Commission returns to work. If I could go to the next slide, Fiona, please. We're just about done. Redundancy. Just a reminder about the position in relation to redundancy. The COVID-19 pandemic unemployment payments are now extended to operate until at least the 8th of June. The wording "at least" is interesting. That's the wording the government is using. It indicates they're going to extend it beyond then. They really have to if they're to follow their roadmap, because under the roadmap, lots of people won't be going back to work until mid to late August at the earliest. The general provisions under the Redundancy Payments Act at present say that if you're laid off or kept on short time and earning less than 50% of your normal pay, you can demand a statutory redundancy payment from your employer. If that's been going on for over 4 weeks. But in those circumstances, the employer then has 4 weeks within which to respond, and they can respond within 4 weeks and give you notice that you're going to be returning to work. And if you're returning to work for 13 weeks on your regular hours, if you're off short time, off layoff, then you're not entitled to redundancy. That's the general rule. The Emergency Measures in the Public Interest COVID-19 Act 2020 suspended that general rule. Okay, so at present, employees cannot demand redundancy payments if they're kept laid off for quite some time. It's suspended during what they're calling the emergency period. At the moment, the emergency period under the legislation runs until the end of this month. But I expect that that legislation will be rolled over, that the emergency period will be extended into June, July, and even August. So I don't think there's a great risk that employees will be able to come and demand redundancy payments from you until possibly September for many employers. But we'll have to wait and see if the government delivers an extension at the end of May. I do think it will happen. Just in conclusion then, Fiona, if you could take us to the next slide there, please. We have an unprecedented situation in terms of the lifetime of modern employment law. I see modern employment law in Ireland going from 1967, which is when the first really significant piece of employment legislation was introduced. Here, the Redundancy Payments Act commenced at that point in time. At present, the law is not well positioned to cope because we haven't had a crazy, horrendous situation like that, or like we're enduring at the moment, in that period of time. More legislative intervention is going to be required. We've had some. They've done relatively well with it so far, but we're going to need more legislation, and with no Seanad operating at present, it's difficult to introduce new legislation. It's impossible to introduce legislation. Ministers are introducing regulations where they're empowered to do so under existing legislation, but they're going to have to get the Seanad up and running. They're going to have to be able to pass legislation over the summer. We're going to see more and more legislation and or regulations introduced over the next 2 to 3 months, I suspect. Opening up the economy may be more technically challenging than closing it. There's going to be all sorts of litigation around this. Litigation against the state, litigation against employers, going to be horrendous, to be perfectly honest. The best case scenario is semi-normal operations in September. Semi-normal, not normal, because I don't really expect to be going to the pub in September. I don't really expect to see hotels in full operation in September. But even September might not be realistic. There are ongoing serious concerns regarding people's health and safety and even survival. And I think it's worth remembering that particularly older people are at huge risk. And I have to say, I would be very supportive of the efforts the government is making to protect those individuals. And I don't think anybody on the call would disagree with that. At the same time, there's massive economic pressure building. We need guidance. So the protocol is to be welcomed in that context because it does give some guidance, but it definitely contains a number of legal and logistical landmines. I'm still trying to envisage all of the businesses in town in which I'm operating in Scorthy, temperature testing everybody at the door. Just can't see it happening. Implementing legislation could be almost impossible for lots of small businesses to follow. If it's impossible, they'll end up getting sued. And I think, unfortunately, we continue to remain in a situation where both jobs and lives are at risk. Now, Patrick asked, in retail, do you have to keep a log of customers an employee has had over the course of the day? Well, the protocol doesn't give us an absolutely clear answer on that, Patrick, but we will get further guidance. I think they're effectively, if you read it as it stands at present, it's implying that you do. Of course, you can't force customers to give you their names, so I think it's going to be almost impossible to do that. But it's a question that is inevitably going to arise and be put to government over the course of this week. And I think we'll see further guidance emerging on that particular point within a fortnight. So you're one of the first people to ask the question, Patrick. You're definitely not going to be the last. I can't answer it definitively right now because the government hasn't indicated the response. But I suspect that if you read what's out there right along, it does imply that you'll have to do that, yes. And Anonymous asks, does track and trace mean we have to take all our customers' details, name and number? What if customers refuse? It's implying that at the moment. That does give rise to significant data protection concerns. If customers refuse, of course, you're not going to be in a position to rugby tackle them and beat the answers out of them. So it's going to be an impossible task for retailers to comply with. So yeah, what happens in these situations is governments rapidly prepare guidance. They've done that. And of course, because of the rapidity with which they're proceeding in doing so, there are gaps, there are problems, and you're identifying one of those problems there, a number of you. And I'm afraid I simply can't give you a definitive answer. All I can say is at present, based on the guidance that I've seen, having considered it over the course of the last 24 hours, yes, you do need to look for that contact information in order to facilitate contact tracing over the next few months. The practicality of actually getting the information is going to be far more problematic. So you're asking the right questions, and hopefully we'll get answers from government over the course of the next week. So thank you all for joining us this morning. Thank you to Fiona and to Karen and to County Wexford Chamber and County Wexford SkillNet for facilitating the webinar and for being so kind to me and coping with my technological inadequacies. I hope that I dealt with your questions as they were coming in there. If there are any other questions, I'm happy to take them now. Otherwise, please everybody stay safe, and I wish you all every success as you return to work over the course of the next 2 to 3 months.
Adrian, thank you so much. A really interesting and insightful presentation. So much to think about, so up to the minute. So thank you for all your efforts over the weekend, putting all that new information into such a concise presentation. I mean, I think we could have spoken for 2 hours at least on this topic. So thank you for the extra time you gave us. Just in terms of the protocols, County Wexford Chamber are going to bring out some initiatives to work with businesses to help them to get back to work. So we're looking to hear from anybody who would like specific supports, and we've had some thoughts on this already. Chambers Ireland are highly involved in the protocol development, and we have been at the table with the government ministers trying to ensure that, you know, there is supports there available to businesses to reopen, and I'd like you to know that. And we will continue to host high quality webinars such as this. Once again, thank you to all of you who joined us today. Thank you to Adrian. Thank you to Karen for facilitating this, and to Aoife. And if there are any questions after the fact, please send an email to us. I think you've been liaising with Aoife Connick at wexfordchamber.ie. We'll send out the slides. They'll also be available on our website. And anything else we can help you with, please don't hesitate to contact. So for now, long live Kildare.